I never thought I would be the type of person to sue my homeowners association. But there I was, sitting in a courtroom in Boulder County, Colorado, watching the judge flip through a stack of photographs showing my perfectly cleared driveway. My name is Marcus Galloway, and I had lived in the Willow Creek Estates subdivision for 3 years before everything went sideways. The neighborhood was nice enough, tucked into the foothills west of Denver with decent views of the mountains and relatively quiet streets. I worked from home as a software engineer, which meant I had a flexible schedule and could handle things like snow removal on my own time. That flexibility, as it turned out, would become the center of a ridiculous conflict that consumed 6 months of my life. The trouble started in January, during one of those typical Colorado snowstorms that dumps 8 inches overnight and then clears up by noon. I woke up around 7 in the morning, checked my work emails, and saw that my team meeting had been pushed back to the afternoon. Perfect, I thought. I would shovel after breakfast, maybe around 9 or 10, once the snow had stopped completely, and the sun had come out to make the work a bit easier. I made myself some coffee, ate a bowl of oatmeal, and settled into my home office to answer a few urgent messages. Around 9:30, I bundled up and headed outside with my snow shovel. The storm had passed, leaving behind that brilliant blue sky that only seems to exist in Colorado winters. I cleared my driveway methodically, working up a decent sweat despite the cold. The whole job took maybe 40 minutes. By 10:15, my driveway was completely clear, the snow piled neatly on the edges of my property. I went back inside, took a hot shower, and did not think about it again until 3 days later when a letter appeared in my mailbox. The envelope had the Willow Creek Estates HOA logo printed in the corner, and I felt a small knot of dread form in my stomach before I even opened it. Nothing good ever came from the HOA. Inside was a violation notice stating that I had failed to remove snow from my driveway in a timely manner, referencing Section 4.7 of the HOA covenants, which required snow removal within 4 hours of a storm ending. The fine was $75. I read it 3 times, convinced I was missing something. The storm had ended around 7 in the morning, and I had finished shoveling by 10:15. That was just over 3 hours. I had been well within the 4-hour window. I immediately drafted an email to the HOA board, explaining the timeline and requesting that the fine be reversed. I included photos from my phone showing the timestamp of when I had finished shoveling. The response came 2 days later from Patricia Henderson, the HOA president. Patricia was exactly the kind of person you would imagine running a homeowners association with an iron fist. She was in her mid-50s, always wore pantsuits even to casual neighborhood gatherings, and had perfected a condescending smile that made you feel like a scolded child. Her email was brief and unhelpful. She claimed that a board member had driven through the neighborhood at 8:30 that morning and documented that my driveway had not yet been cleared. Therefore, I was in violation. The fine stood. If I wished to appeal, I could attend the next board meeting in 2 weeks. I marked the date on my calendar and spent the next 14 days getting increasingly annoyed. The whole thing was absurd. I had cleared my snow in time. The fact that someone had driven by before I finished did not change that. It was like getting a speeding ticket for driving 30 in a 35 zone just because a cop saw you accelerating. The board meeting was held in the community center, a bland building near the neighborhood entrance that mostly sat empty except for these monthly gatherings. I arrived 15 minutes early and found about a dozen other homeowners already seated in the folding chairs arranged in rows. Patricia sat at a table up front with 4 other board members, shuffling papers and whispering amongst themselves. When my turn came to speak, I stood and calmly explained the situation. I showed the timeline, the photos, the email chain. I pointed out that I had been well within the required window. Patricia listened with that same condescending smile, occasionally nodding as if she was humoring a confused child. When I finished, she glanced at her fellow board members and then back at me. "Mr. Galloway, the rule exists to ensure our neighborhood maintains its standards. Our board member observed your property with snow still present at 8:30. That is a documented fact. Whether you eventually cleared it is beside the point. The violation occurred when the snow remained past the acceptable window." I stared at her, genuinely confused. "But the window is 4 hours. The storm ended at 7. 8:30 is only an hour and a half later." Patricia folded her hands on the table. "The storm ended at 6:45, according to the National Weather Service data. Therefore, your window closed at 10:45. Our board member observed the violation at 8:30, at which point you should have already begun work." I felt my face getting hot. "You just said I was in violation at 8:30, which would mean the window had already closed. But now you are saying the window did not close until 10:45. Which is it?" She did not miss a beat. "You were in violation because you had not made any effort to clear the snow at the time of observation. The rule is intended to ensure prompt action." "That's not what the rule says. It says 4 hours from the end of the storm. I finished at 10:15. That's within the window." Another board member, a thin man in his 60s named Gerald, leaned forward. "Mr. Galloway, we understand your frustration, but rules are rules. If we make exceptions, the whole system falls apart. The fine stands. This meeting is adjourned on this matter." I sat down, stunned. I had never been the type to make waves or fight with authority, but this was so blatantly unfair that I could not just let it go. After the meeting, I approached Patricia directly and asked if we could discuss it further. She waved me off, saying the decision was final and that I should just pay the fine to avoid late fees. I went home and did what any reasonable person would do in 2026. I researched Colorado HOA law until my eyes crossed. I learned about the Colorado Common Interest Ownership Act, about dispute resolution procedures, about the limits of HOA authority. The more I read, the more convinced I became that the HOA was not just being unreasonable. They were potentially violating state law by imposing arbitrary and inconsistent enforcement of their own rules. I decided not to pay the fine. Instead, I sent a formal letter to the board citing the specific covenant language, the timeline of events, and requesting that they provide clear documentation of how they determined I was in violation. I also requested the exact time the storm ended according to their calculations, and the credentials of whomever had made that determination. Patricia responded with another form letter saying my appeal had been considered and denied. A second fine was added, this time for $50 for failure to pay the original fine within 30 days. That was in February. By March, the situation had escalated beyond anything I could have imagined. Another snowstorm hit in mid-February, and this time I was determined to document everything. I set my alarm for 6 in the morning and checked the weather radar obsessively. The snow stopped falling at 5:47 in the morning, according to my weather app and the National Weather Service website, which I screenshotted. I was outside with my shovel by 6:30, and I had my phone set up to record the entire shoveling process. I finished at 7:18. Well within the 4-hour window by any possible calculation. 3 days later, another violation notice arrived. Same thing. failure to remove snow in a timely manner, $75 fine. I nearly threw the letter across the room. This time, Patricia's accompanying email claimed that their board member had observed my driveway at 6:15 and the snow was still present. I sent back my video evidence, my screenshots, my timestamps, everything. Her response was infuriating. She said that video evidence was not acceptable because it could be manipulated, and that the board's observation took precedence. I called an emergency meeting request, which was my right under the HOA bylaws. Patricia denied it, saying my matter did not constitute an emergency. I filed a formal complaint with the state's HOA regulatory office, but they said it could take months to investigate and that I should consider mediation. By April, I had racked up 4 separate violations, each one more ridiculous than the last. The third came when I had cleared my snow within 2 hours of the storm ending, but Patricia claimed I had created an unsafe pile at the edge of my driveway that blocked visibility. The fourth came when I apparently tracked snow from my driveway onto the sidewalk while shoveling, creating a hazardous condition. Each violation came with a $75 fine, plus late fees that accumulated when I refused to pay. The breaking point came in early May. I was working in my home office when I heard a vehicle slow down in front of my house. I glanced out the window and saw Patricia sitting in her silver SUV, taking photos of my property with a large camera. I watched her for a few minutes, confused, then went back to work. The next day, I received a violation notice for having my trash cans visible from the street. The thing was, it was trash day. Everyone's cans were out. I walked the neighborhood that evening and counted 23 other houses with visible trash cans. Only I had received a violation. That night, I started keeping a log. Every time I saw Patricia or another board member driving slowly past my house, I noted the date and time. Every violation I received, I compared against similar situations at other houses in the neighborhood. A pattern emerged quickly. I was being targeted. In June, I received my 8th violation, this time for having a garden hose visible in my front yard. The hose had been there for 2 days while I watered some newly planted shrubs. I decided enough was enough. I contacted 3 different attorneys who specialized in HOA disputes. The first 2 told me that it would cost more in legal fees than I could possibly win. The third attorney, a woman named Rebecca Chen who worked out of a small office in Boulder, listened to my entire story and then leaned back in her chair. "This is harassment," she said simply. "Colorado law is pretty clear about selective enforcement and targeted violations. If you can prove that they're singling you out, we have a case." I showed her my logs, my comparison photos of other properties, my documentation of every interaction. She nodded slowly, making notes. "Here's what I think happened," Rebecca said. "You challenged them at that first board meeting. You made Patricia look bad in front of other homeowners. Now she's got it out for you, and she's using her position to make your life difficult. The good news is that this kind of behavior is actionable. The bad news is that suing an HOA is expensive and time-consuming." I asked about costs. She quoted me a retainer of $3,000, with additional fees depending on how far things went. It seemed insane to spend $3,000 fighting maybe $600 in fines, but at that point, it was not about the money anymore. It was about the principle. It was about stopping Patricia from doing this to me or anyone else. I hired Rebecca that day. She immediately sent a cease and desist letter to the HOA board, demanding they stop the targeted harassment and withdraw all fines. Patricia's response, through the HOA's attorney, was dismissive. They denied any wrongdoing and said they would see us in court if necessary. So we went to court. Rebecca filed a lawsuit in Boulder County District Court in July, alleging harassment, selective enforcement, and violation of Colorado HOA statutes. We asked for damages, legal fees, and an injunction preventing the HOA from further violations against me without proper cause. The discovery process was eye-opening. Through subpoenas, we obtained all of the HOA's violation records for the past 2 years. The pattern was undeniable. In the first 2 years I lived in Willow Creek Estates, I had received 0 violations. Then, after that first board meeting in January, I received 8 violations in 6 months. During that same period, the rest of the neighborhood, about 80 homes, had collectively received 11 violations total. I alone had received more violations than the entire rest of the community combined. Even better, we obtained Patricia's emails. The HOA was required to turn over all correspondence related to violations and board decisions. Buried in those emails were some truly damning exchanges. In one, Patricia wrote to another board member named Susan about keeping an eye on that troublemaker on Oakmont Drive, which was my street. In another, she explicitly stated that she wanted to make an example of homeowners who questioned the board's authority. Rebecca was thrilled. "This is even better than I hoped," she told me over the phone. "She basically admitted to targeting you in writing. HOA boards have authority, but they cannot abuse it. This is textbook abuse." The HOA's attorney tried to settle before trial. They offered to withdraw the fines and call it even. Rebecca advised me to reject the offer. We were not just seeking the withdrawal of bogus fines. We were seeking damages for the time, stress, and harassment I had endured. Plus, I wanted to make sure this did not happen to anyone else. The trial was scheduled for October. As the date approached, I felt increasingly nervous. I had never been involved in a lawsuit before. The idea of sitting in a courtroom being questioned by attorneys, having my life examined, it all felt overwhelming. Rebecca assured me that we had a strong case and that I just needed to tell the truth. The trial lasted 2 days. The courtroom was smaller than I expected, with wooden benches and a distinctly municipal feel. The judge was a no-nonsense woman in her 60s named Judge Sandra Morrison, who had a reputation for not tolerating games. Rebecca presented our case methodically. She walked through the timeline of violations, showed the comparative data from the rest of the neighborhood, and entered Patricia's emails into evidence. She called me to the stand and had me explain each violation in detail, along with my evidence that I had been in compliance or that other homeowners had similar situations without receiving violations. The HOA's attorney, a man named Richard Kruger who looked like he would rather be anywhere else, tried to argue that the board had the authority to enforce standards and that all violations had been legitimate. But when Rebecca cross-examined Patricia, things fell apart for them quickly. Patricia sat on the witness stand in one of her trademark pantsuits, maintaining her condescending smile even as Rebecca dismantled her story piece by piece. "Mrs. Henderson, you stated in your deposition that you personally observed Mr. Galloway's driveway on January 15th at 8:30 in the morning, correct?" "Yes, that's correct." "And you documented that the snow had not been removed?" "Yes." "But according to your own records, you sent the violation notice 3 days later. If this was truly about safety and maintaining neighborhood standards, why did you wait 3 days to notify him?" Patricia hesitated. "We process violations on a schedule." The notice went out on the next administrative day. Rebecca held up a piece of paper. "But here's a violation notice you sent to another homeowner, Mr. Chen on Maple Street, dated the same day as the alleged violation." Why did Mr. Chen get same-day notification while Mr. Galloway had to wait 3 days? I don't recall the specific circumstances. Let me refresh your memory. Mr. Chen's violation was for a lawn care issue, not a safety issue like snow removal, which you have testified is time-sensitive. Yet he got immediate notification and Mr. Galloway did not. Does that seem like consistent enforcement to you? Patricia's smile wavered. Each situation is different. Rebecca moved on to the emails. She projected them on a screen for the whole courtroom to see. When she got to the one about keeping an eye on that troublemaker, Patricia's face flushed. Mrs. Henderson, can you explain what you meant by troublemaker in this email dated February 3rd? I was referring to homeowners who don't follow the rules. But Mr. Galloway had only received one violation at that point, which he had appealed. That hardly seems like a pattern of not following rules. In fact, it seems like he was exercising his right to challenge what he believed was an incorrect violation. Would you call someone a troublemaker simply for appealing a fine? That's not what I meant. Then, what did you mean? Patricia did not have a good answer. Judge Morrison watched the whole exchange with an unreadable expression, occasionally making notes. The HOA's attorney tried to recover on redirect, asking Patricia about her years of service to the community and her dedication to maintaining property values. But the damage was done. The emails made it clear that this was personal, not procedural. On the second day, Rebecca called an expert witness, a professor from the University of Colorado who specialized in HOA law and governance. He testified that the pattern of violations against me, combined with the selective enforcement and the documented evidence of bias, constituted harassment under Colorado law. He explained that while HOA boards had broad authority, that authority was not unlimited and could not be used to target individual homeowners based on personal grievances. When both sides rested, Judge Morrison took a short recess before delivering her ruling. We all stood as she returned to the bench. My heart was pounding so hard I could hear it in my ears. Judge Morrison looked directly at me and then at Patricia before speaking. I have reviewed all the evidence presented, including the documentation, emails, and testimony from both parties. It is clear to this court that the Willow Creek Estates HOA Board, specifically through the actions of its president, Mrs. Henderson, engaged in a pattern of selective enforcement and harassment against Mr. Galloway. She continued, her voice firm. HOA boards serve an important function in maintaining community standards, but that authority comes with a responsibility to act fairly and consistently. The evidence shows that Mr. Galloway received more than 8 violations in a 6-month period, while the rest of the community received 11 total. More damning, the emails entered into evidence demonstrate a personal animus and an intent to target Mr. Galloway specifically because he challenged a violation he believed to be incorrect. This is precisely the kind of abuse of authority that Colorado law prohibits. I felt Rebecca squeeze my arm gently. Judge Morrison was not done. The court finds in favor of the plaintiff, Mr. Galloway. All fines and violations issued by the Willow Creek Estates HOA against Mr. Galloway are hereby nullified and withdrawn. Furthermore, the court awards Mr. Galloway damages in the amount of $3,000 for the harassment and stress caused by the HOA's actions. The HOA is also responsible for Mr. Galloway's legal fees, which will be calculated and submitted to the court within 30 days. Patricia's face went pale. The judge concluded by issuing an injunction prohibiting the HOA from issuing any further violations against me without clear, documented evidence and proof of consistent enforcement against other homeowners in similar situations. When the gavel came down, I felt a wave of relief so intense I almost laughed. Rebecca shook my hand and congratulated me. We walked out of the courtroom together, and I noticed Patricia hurrying out a side door, avoiding eye contact. The aftermath was more satisfying than I could have imagined. Within a week, news of the lawsuit spread through the neighborhood. I started receiving emails and knocks on my door from other homeowners, sharing their own stories of questionable violations and Patricia's heavy-handed tactics. 3 other homeowners contacted Rebecca about potential lawsuits of their own. The HOA held an emergency board meeting in November, and Patricia resigned as president. The official statement said she was stepping down for personal reasons, but everyone knew the truth. The new board president was a reasonable man named Tom who lived 2 streets over. One of his first acts was to institute a new violation policy requiring photographic evidence, timestamps, and proof that similar situations were being addressed consistently across the neighborhood. They also created an appeals process that involved an independent third party, not just the board itself. I received my $3,000 check from the HOA in early December. The legal fees, which totaled just under $8,000, took longer to process, but Rebecca assured me they would come through. Opening that check felt surreal. It was not about the money, really, but it was a tangible acknowledgement that I had been right, that I had been wronged, and that fighting back had been worth it. Christmas in Willow Creek Estates that year had a different feel. Several neighbors invited me to holiday gatherings, and I found myself actually enjoying the community for the first time since that first violation notice had arrived nearly a year earlier. People approached me at parties to thank me for standing up to Patricia and the old board. One woman, elderly Mrs. Phillips, who lived at the end of my street, told me she had received a violation for having her porch light out, even though she had been in the hospital at the time. She had just paid the fine because she did not think she could fight it. Hearing stories like that reinforced that I had done the right thing. In January, exactly 1 year after that first ridiculous violation, we got another big snowstorm. I woke up early, checked the weather radar, and noted that the snow stopped at 6:23 in the morning. I made myself coffee, ate breakfast, and then went outside to shovel. Several neighbors were doing the same, and we waved to each other in that universal gesture of shared winter misery. I finished clearing my driveway around 8:30 and went back inside to warm up. I did not receive a violation notice. I did not see anyone from the HOA driving slowly past my house taking photos. The new board was focused on actual community improvement projects, like fixing the playground equipment and organizing neighborhood events, rather than generating violation notices to justify their authority. Looking back, the whole experience taught me some valuable lessons. First, documentation is everything. If I had not kept detailed records, taken photos and videos, and saved every email, I never would have been able to prove my case. Second, standing up to unfair authority is worth it, even when it seems easier to just pay the fine and move on. Patricia was counting on people doing exactly that, accepting the injustice because fighting it seemed too expensive or too difficult. By refusing to back down, I not only resolved my own situation, but potentially helped other homeowners avoid similar harassment. Third, not all HOAs are bad, but they are made up of people, and people can abuse power when they are not held accountable. The new board was proof that an HOA could function properly, enforcing reasonable rules fairly without turning into a neighborhood police state. It just required people who saw their role as serving the community rather than controlling it. I also learned that the legal system, for all its flaws and expenses, can work when you have a clear case and good representation. Rebecca Chen was worth every penny of that retainer. She understood both the legal issues and the personal aspect of what I was going through. She never made me feel stupid for caring about what seemed like small violations, because she recognized that it was never really about snow removal timing or garden hoses. It was about someone in a position of authority deciding they did not like me and using their power to make my life difficult. By February, Rebecca called to tell me the HOA had paid the full amount of legal fees. The check arrived the following week. I took Rebecca out for a nice dinner to celebrate and to thank her properly. Over dessert, she told me that 2 other homeowners from Willow Creek Estates had retained her for their own cases against the previous board's actions. Patricia's reign of petty tyranny was having lasting legal consequences. In March, I attended my first HOA board meeting since the lawsuit. The atmosphere was completely different. Tom, the new president, ran the meeting efficiently and respectfully. When a homeowner raised a concern about unclear language in one of the covenants, Tom promised to have the board review it and propose clearer language at the next meeting. There was no condescension, no dismissiveness, just actual community governance. It was remarkable how much better things functioned when the board saw homeowners as neighbors rather than subordinates. Spring arrived, and with it came the annual neighborhood cleanup day. I volunteered to help, spending a Saturday morning picking up litter and doing basic maintenance around the community center. Patricia had always organized this event in previous years, using it as an opportunity to lecture everyone about covenant compliance. This year, Tom just provided trash bags and thank you, and we all worked together like actual neighbors. One afternoon in April, I ran into Patricia at the grocery store. We made eye contact across the produce section, and for a moment I thought she might just turn and walk away. Instead, she approached me, looking uncomfortable. "Marcus," she said stiffly, "I wanted to say something to you." I waited, genuinely curious what this would be. She took a breath. "I have been doing a lot of thinking since everything happened. I talked to a therapist about it, actually." She helped me understand that I had gotten too wrapped up in the HOA role, that I had started seeing any challenge to my decisions as a personal attack. "I am not good at apologizing, but I am sorry for what I put you through. It was wrong." I was genuinely surprised. This was not the Patricia I had come to know. "I appreciate you saying that," I told her. "It takes courage to admit when you are wrong." She nodded, looking relieved. "I have stepped back from all my volunteer positions, trying to focus on other things. Anyway, I just wanted you to know." She walked away before I could respond further, her cart squeaking slightly as she headed toward the dairy section. I stood there for a moment, processing the interaction. I did not know if Patricia's apology changed anything materially, but it did provide a sense of closure. She had been wrong, she knew it, and she had acknowledged it. That was more than I expected. Summer came, and life in Willow Creek Estates settled into a comfortable routine. The new board continued making reasonable decisions. The violation notices that did go out were for genuine issues like actually abandoned vehicles or truly neglected properties, and they were enforced consistently. I worked in my home office, shoveled my driveway when it snowed, and lived my life without constantly looking over my shoulder for Patricia's silver SUV. In August, I received an invitation to speak at a Colorado HOA Association conference about homeowner rights and the importance of fair enforcement. Rebecca had recommended me to the organizers. I was nervous about public speaking, but I agreed to do it. If my experience could help other homeowners understand their rights, or help board members understand the line between enforcement and harassment, it would be worth the anxiety. The conference was in Colorado Springs, and about 60 people attended my session. I told the story of my lawsuit, focusing on the lessons learned and the importance of documentation. During the question and answer period, several people shared their own HOA horror stories. Others, board members themselves, asked thoughtful questions about how to enforce rules fairly without ending up in my situation. It was a good conversation, and I left feeling like maybe something positive had come from those frustrating months of fighting with Patricia. Fall arrived, and with it came the anniversary of the trial. It had been a year since Judge Morrison had ruled in my favor, and life had completely stabilized. The $3,000 in damages had gone toward a new deck in my backyard, a project I had been putting off. Every time I sat on that deck with a beer, watching the sunset over the mountains, I thought about the journey that had funded it. It was a weird kind of memorial to standing up for yourself. In October, the annual HOA election happened. Tom ran for another term as president and won easily. The other board positions were filled by reasonable neighbors who actually seemed interested in community building rather than power trips. During the meeting where the new board was sworn in, Tom mentioned the importance of learning from past mistakes and committed to transparent, fair governance. Several people glanced at me when he said it, and I felt a quiet sense of satisfaction. Winter came around again, and with the first significant snowstorm of the season, I found myself thinking about that initial violation notice that had started everything. It seemed so long ago now, that morning when I had opened my mailbox and found the $75 fine for snow removal timing. If someone had told me then that it would lead to a lawsuit, a trial, Patricia's resignation, and reforms to how the entire HOA operated, I would not have believed them. But that is exactly what happened. I cleared my driveway that morning within the required 4 hours, just as I always had. The difference was that now I did not need to document it obsessively or worry about cameras and violation notices. I just shoveled my snow, waved to my neighbors doing the same, and went back inside to warm up. It was such a simple thing, such a normal part of living in Colorado, and yet for those months during the harassment it had become this stressful ordeal. Having that normalcy back was worth more than any damage award. As Christmas approached, I reflected on the entire experience. It had been exhausting, expensive, and stressful. There were times I had wanted to just give up, pay the fines, and move on with my life. But I had not, and that decision had rippled outward in ways I could not have predicted. Patricia had gotten help and apologized. The HOA had reformed its practices. Other homeowners had been empowered to challenge unfair treatment, and I had learned that I was capable of standing up for myself even when it was difficult. The $3,000 award was nice, and getting the legal fees covered meant I had not lost money on the principal. But the real victory was the change in how the HOA operated, and the knowledge that I had refused to be bullied by someone who had abused their position of authority. That was worth more than any check. On Christmas Eve, I attended the neighborhood party at the community center. It was packed with families, kids running around, people laughing and sharing food. Tom gave a short speech thanking everyone for making Willow Creek Estates such a great community. He did not mention the lawsuit or Patricia or any of the drama from the previous year. He did not need to. Everyone there knew how things had changed and why. I mingled with neighbors, accepted thanks from a few people who appreciated what I had done, and generally enjoyed myself. Mrs. Phillips, the elderly woman who had told me about her porch light violation, approached me with a plate of homemade cookies. "These are for you, dear," she said, pressing the plate into my hands. Thank you for being brave when the rest of us were not." I thanked her and promised the cookies would not last long. As I stood there in the community center, surrounded by neighbors who actually felt like a community now, I realized this was what an HOA was supposed to facilitate. Not endless violation notices and power trips, but actual neighborly connection and shared investment in where we lived. When I got home that night, I sat on my deck despite the cold, wrapped in a heavy coat and watching the Christmas lights twinkling on houses throughout the neighborhood. My house had lights too, carefully hung according to the HOA guidelines that actually made sense and were enforced fairly. No one was going to fine me for the strand placement or the color temperature of the bulbs, because the new board understood that reasonable people could have different aesthetic preferences within sensible guidelines. I thought about everything that had happened since that first violation notice. The anger and frustration, the decision to fight back, finding Rebecca, the discovery process revealing Patricia's emails, the trial and Judge Morrison's ruling, Patricia's apology, the reforms, speaking at the conference. All of it had stemmed from refusing to accept an unfair $75 fine for snow removal timing. The lawsuit had been about more than money or vindication, though those were nice. It had been about the principle that people in positions of authority cannot abuse that authority without consequences. It had been about standing up for fair treatment and consistent application of rules. It had been about refusing to be a victim of someone else's power trip. As I sat there in the cold, I felt genuinely grateful for how everything had turned out. Not grateful for the harassment, obviously, but grateful that I had found the strength to fight it. Grateful for Rebecca's expertise and Judge Morrison's fairness. Grateful for the new board and the reforms they had implemented. Grateful for neighbors who appreciated the stand I had taken. The $3,000 had been nice, truly. It had funded a deck project I had wanted, but the real reward was getting my peace of mind back. It was being able to shovel snow without anxiety. It was living in a neighborhood that felt like a community rather than a police state. It was knowing that Patricia could not target anyone else the way she had targeted me. I finished my beer and went inside, locking the door behind me. My home office was set up for work tomorrow, my driveway was clear, and my relationship with the HOA was finally normal. No ongoing disputes, no pending violations, no cameras documenting my every move. Just a normal homeowner in a normal neighborhood with a reasonably functional homeowners association. That night, as I settled into bed, I thought one more time about that morning in January when I had opened my mailbox and found the first violation notice. I had been so angry, so convinced it was unfair. I had been right to be angry and right to fight. The journey from that moment to this one had been long and difficult, but ultimately worthwhile. I never wanted to sue anyone again. The process had been stressful and consuming. But if faced with similar circumstances, I would do it again in a heartbeat. Because some things are worth fighting for, even when the fight seems disproportionate to the initial wrong. Standing up to bullies and abusers of power, even petty ones in homeowners associations, matters. It matters to you, and it matters to everyone else who might be targeted next. As I drifted off to sleep, I felt satisfied with how everything had resolved. The lawsuit was over, the money had been paid, the reforms were in place, and life had moved on. Patricia was working on herself. The HOA was functioning properly. The neighborhood was peaceful, and I had learned that I was capable of fighting for what was right even when it would have been easier to just accept the injustice. That was the real victory. Not the $3,000 or the withdrawn violations or even Patricia's apology. The real victory was discovering my own backbone and using it to create positive change. Everything else was just details. I had sued my homeowners association for harassment over snow removal timing violations. I had won $3,000 in damages, plus legal fees. But more importantly, I had won my dignity, my peace of mind, and the knowledge that I would never again accept unfair treatment just because someone had a title and a gavel. That was worth more than any amount of money a judge could award. And as I finally fell asleep that Christmas Eve, comfortable in my home in Willow Creek Estates, I knew I had made the right choice every step of the way.